Day 4 of the federal trial for the 3 ex-officers charged in George Floyd's killing offered more witness testimony for the prosecution. Former officers J. Alexander King, Tu Thao, and Thomas Lane are all facing charges of failing to give medical aid. Thao and Kueng are also charged with failing to intervene as Derek Chauvin kneeled on George Floyd's neck for more than 9 minutes, ultimately killing him. Here to discuss today's highlights from court is criminal defense attorney Phillip Hamilton. Glad to have you back, counselor. Listen, so one of the standout witnesses from today was Minneapolis Police Department Inspector Katie Blackwell. She previously served as commander of the department's training division, where she oversaw the police academy and the field training program. Now, during her testimony, she outlined the hundreds of hours of rigorous training all would-be officers receive before they ever step foot on patrol. Her testimony seemed to directly contradict what the defense argued in their opening statements, that some of these defendants were being trained on the very day in question. But according to Blackwell's testimony, they were well prepared. So, Phillip, how does the defense overcome that testimony and convince the jury otherwise?
You've also seen the defense in many respects, Yodit, starting to focus on the fact that the cause of death is up in the air, right? Because I think with Blackwell coming in, they almost have to start going back to this blaming Floyd for his own death, because as you noted, it directly contradicts the way in which they're going about trying to say that they were not trained for this, that, the occasion was something that they couldn't competently handle because, they were still in the process of trying to figure this out. The fact of the matter is the training was there. And to the extent that the government has to prove that these officers willfully failed to intervene in regards to stopping Chauvin, that they willfully failed to provide aid, the testimony from Blackwell is really critical, because what it goes to show is not only, of course, did they know how to stop and how to ultimately render aid, but the fact that they had been trained for that long and decided to do nothing, that's the underpinning of willfully deciding to do nothing. And as you noted, just a very important witness for the prosecution.
Will it work for the defense to make the argument that, okay, sure, fine, you say that they go through training, but the training in and of itself is insufficient? So is an attorney's opinion on whether training for would-be officers is sufficient enough going to overcome an actual trainee within the department who's had a number of years of experience over the attorney? Will that work with jurors?
I don't believe so. And even to the extent that we're in, federal court now, as opposed to this being, tried as a state case, as was the prior matter in Minneapolis, the fact remains, to overcome that is an uphill battle. And it's not to take away from the fact that in this case, no different than in the state case with Chauvin, this is an uphill battle. And in uphill battles with, criminal defense attorneys, and let's be frank, I am one, there are times in these uphill battles where your job is just to simply present a defense. To the extent that it can in any way undercut the prosecution's burden, that's what you present. Of course, you would like to be able to present a stronger narrative, a stronger story. But here, the entire world has seen the events that happened that ultimately led to George Floyd's death. We saw what Chauvin did. We saw what these officers did and what they did not do, which is essentially what they're on trial for now. So in many respects, yes, as defense attorneys, they're going to have to highlight, the fact that they say that the training was insufficient. Is it ultimately going to be enough in regards to what everybody at this point already knows, but even what is being currently presented in federal court by the government? I don't personally believe so.
You raise an interesting point. You talk about the defense blaming Floyd for his own death. We saw that strategy clearly not work in Derek Chauvin's trial. But here's where I'm confused. What is the point in bringing up how George Floyd behaved that day, making this argument to the jury that they don't know what the full context of the videos that they're being shown really is, whether he had drugs in his system? At the end of the day, what matters is what he was behaving like once he actually was under the custody and control of these law enforcement officers. He was on his stomach, on the ground. He had officers on him. He had Chauvin's knee in his neck, and he was handcuffed. He wasn't resisting. So doesn't that matter versus everything else that they're saying happened before?
Of course it matters. And that's why they have to focus so heavily on what happened before. A lot of the things that couldn't be seen, right? Going to Mr. Floyd's personal character and his character traits, essentially just a number of red herrings to distract from what you just hit the nail on the head about. We all saw him in the custody of those officers on the ground, unable to in any way help himself because he's handcuffed. There's a knee on the back of his neck, and there's officers who are, rendering him unable to be able to move, in regards to his legs and in regards to his torso. And so, because we know that, the defense, to the extent that they want to put forth any effective strategy, they have to distract and they have to deflect. So I'm not surprised that they're going that route. But again, when we go back to the ultimate question of will it prove fruitful, I don't personally believe so.
All right, Phillip, I want to take a step back now and look at another witness the jury heard from yesterday. The state called Derek Smith. He was the first paramedic on the scene, and Smith walked jurors through what happened after he arrived on the scene. One thing that stood out to me was when he brought up Officer Lane's response once paramedics arrived. Smith testified that Lane climbed into the ambulance to see if he could help administer CPR. Now, it's important to note that Lane was also the only one who twice suggested that Floyd be rolled over onto his side. Now, given given his show, that is, of concern under the circumstances where it's his, 6th or 7th day on the job, where he's got a more senior officer, Chauvin, who's calling all the shots, could the jury be more sympathetic towards his attempts as opposed to his co-defendants?
Look, as a defense attorney, whenever you go into a case, of course, you always want to humanize your client. You want to be able to tell that story that, as you noted, can be the hook for the sympathy. And so if I ultimately am Lane's attorneys, the point that you just focused on is one that very heavily and thematically throughout the course of my defense, I will be bringing up and harping upon. Still, prior to jumping into the ambulance, there was at least 9 minutes that his officer, I don't care if it's a senior officer, was taking the life of Mr. Floyd. He is on trial for that, for the failure to render aid and for the failure to intervene. The fact that this is your supervisor, whereas though that may have some kind of influence on your economic interest or your job, when we're looking at the law and the fact that there was a man's life here who you have a duty and have taken an oath to uphold the safety for, the fact that it's your supervisor, that doesn't withstand anything. Your job in that situation is not to be in a position where you're just letting this man die. And so that's why he was indicted. That's why he's on trial. Now, if he's able to, in some way, as you noted, elicit sympathy from the jury and it ends up working in his favor, then so be it. But in terms of him being here, there's a reason why he's here. And with respect to that reason, him being indicted for having failed to intervene and render aid, he could ultimately be convicted, and he knows that.
Phillip, we also heard from Genevieve Hansen on Wednesday. She's the off-duty firefighter who witnessed George Floyd's murder. She told the court that she felt she needed to keep her phone, her camera phone, pointed directly at Officer Thao because she felt he was the one preventing Floyd from receiving proper medical care. And she testified that when she tried to offer the officers help, she was told by Thao, quote, "If you were really an officer or firefighter, that is, then you would know to get back and stay on the sidewalk." Her testimony seemed pretty damning, specifically for Thao. And on cross-examination, his defense attorney made a point to get her to say that, listen, you didn't know what the circumstances were before you came on scene. You don't know anything about what Thao needed to do in that situation. And she obviously agreed that she didn't. But how damning is that she specifically pointed to one defendant versus the others? And can the jury really make that a separation in their minds? Because it's really hard when you have co-defendants in one trial to really divvy up their particular actions to each individual.
The problem that Thao has is that he was on video coming across very rude, coming across very obstructive and obtuse to a crowd that clearly cared about Mr. Floyd and his life. And so I think that when you have Hansen, who comes across very compassionate and very, in many respects, concerned about Floyd in a way that he wasn't, it can single him out in a way that could potentially be destructive ultimately for his case.
All right, Phillip Hamilton, thank you so much for your time and your insight.